was he said that I alleged retaliation when an employee of Effluent Retrieval Services terminated me. Completely wrong. Not the case. Not the facts. I allege that I was retaliated because the owner of Effluent Retrieval Services terminated me. This is why Judge Patriot couldn't get to my retaliation claim, or that he didn't get to my retaliation claim, because I couldn't base my retaliation claim on it being terminated by an employee. You know, I only could base my my retaliation claim on being terminated by the owner of the company, Effluent Retrieval Services. So, by Judge Patriot misstating the facts, again, we see tactics against pro se litigants that are designed to give the defendants leverage, and this cannot continue in that manner. You know, this is what the Unemployment Board of Compensation, the Unemployment Board of Review, Unemployment Compensation Board of Review, excuse me. This is what happened when I filed my appeal. It says here, this is the order of the Unemployment Compensation Board of Review. The claimant request for reconsideration is granted. The decision of the board is issued on the above date is vacated. This matter is reopened to hold a remand hearing to receive testimony from the claimant regarding his non-appearance at the prior hearing and to receive additional testimony and evidence on the merits. However, such additional testimony will only be considered if the board finds that the claimant demonstrated proper cause for his non-appearance. Regardless of whether the additional merits evidence is considered, the board shall issue a new decision taking into account the claimant's argument on reconsideration that the employer, as a matter of law, did not prove that he was self-employed. This record is reopened and this matter is remanded for another hearing before a referee acting as a hearing officer for the board with notice to all interested parties. The scope of the hearing will be governed by the memorandum of the board that accompanies the notice of hearing. Testimony resulting from the further hearing will be transcribed and the entire record returned to the board for its consideration and further action as may be deemed appropriate. So when I appealed, I won the appeal, and we had a hearing. After that hearing, the record was transcribed and sent up to the board. This was the Unemployment Compensation Board of Review. This was their findings. Findings of fact. 1. The claimant performed services wiping cars for Effluent Retrieval Services for a total of 15 days between September and November 2015. 2. The claimant reported to a location where individuals were picked to work. Those chosen then went in a company-provided van to work at various Effluent Retrieval Services clients in Pennsylvania and New Jersey. 3. The claimant could choose whether or not to report for possible work. 4. The claimant was paid by the hour. 5. Supervisors were on location at the work sites to ensure that the cars were wiped correctly. 6. The claimant did not have a business and did not hold himself to others to perform services. 7. The claimant did not appear at the first hearing because his trolley was delayed by another passenger's medical emergency. The claimant called the referee's office to inform the referee of the situation. Discussion. The Department of Labor and Industry issued a determination denying benefits to the claimant and assessing non-fault overpayment. The claimant filed an appeal following a hearing in which the employee employer witness with counsel appeared and testified, the referee issued a decision affirming the department's determination. Thereafter, the claimant filed a further appeal from the referee's decision. The Unemployment Compensation Board of Review issued a decision affirming the referee's decision. The claimant requested reconsideration on the basis that he has good cause for non-appearance at the referee's hearing and that he was not self-employed as a matter of law. The board granted the claimant's request and remanded the case to a referee acting as a hearing officer for the board. Because the claimant had good cause for his failure to appear at the first hearing, the board will base his decision on the testimony presented at both hearings. Section 402H of the law provides that an employee shall be ineligible for compensation for any week in which he is engaged in self-employment. Section 402H of the law is defined by Section 4L2B. Section 4L2B of the law provides that services performed by an individual for wages shall be deemed to be employment subject to this act unless and until it is shown to the satisfaction of the department that A, such individual has been and will continue to be free from control or direction over the performance of such services both under his contract of service and in fact, and B, as to such services such individual is customarily engaged in an independently established trade, occupation, profession, or business. The claimant in this case was taken to the client's location by Effluent Retrieval Services, was paid on an hourly basis, was supervised by Effluent Retrieval Services employees. The claimant performed his services under the direction and control of Effluent Retrieval Services. The claimant did not have a business and did not hold himself out to others to perform the services of wiping down cars. The claimant was not working in an established trade, business, or profession. The claimant does not meet either prong of the test. He is not an independent contractor and cannot be denied benefits under Section 402H of the law. Since the claimant is eligible for benefits, Section 804 of the law is not applicable to the case. The claimant has no overpayment and there can be no recoupment. Conclusion of the law: the claimant is not ineligible for benefits under the provisions of Section 402H of the law. We further build on this. The order of the Unemployment Compensation Board of Review, it says the decision of the referee is reversed and benefits are granted. So, in that form, I showed that I wasn't an independent contractor. They petitioned for review in the Commonwealth Court of Pennsylvania, but this is what this is their objections. That one, work was available for Smith at Effluent Retrieval Services after his last day of work at Effluent Retrieval Services, and he declined to avail himself of it. First and foremost, if work is available, that can only be available for an employee and not for an independent contractor, because an independent contractor, as established, is he creates his own work. So when they say that work was available for Smith, that means that I was an employee, point blank, period. You know what I mean? But I want you to see, how Effluent Retrieval Services are making different defenses in the federal court and in the lower form where the Unemployment Compensation Board of Review is concerned. They taking different stances, because in this form, this form don't know what they saying, and in this form don't know what they saying. So, they're able to, switch up and change up their defenses, their positions, and things of that nature. But it's crazy because, this should be able to be presented to both forums so they can see, the craftiness and what Effluent Retrieval Services is doing, switching up their position. If I was an independent contractor, you shouldn't have to switch up your position. It should strictly continue to be, that I was an independent contractor. Their second objection is that I was incarcerated during 2015, which, you know, I was, but that was before I was even employed by Effluent Retrieval Service. I was incarcerated in June, and I was only incarcerated for 26 days, pardon me. I started working for Effluent Retrieval Services in September, you know what I mean? So I don't even know why they, you know, chose to use that as an objection. Then the third objection is Smith is ineligible because during his base year he was not employed for a sufficient amount of time or received too little wages to qualify for compensation, whatever. Their fourth objection is Smith is ineligible because he failed to engage in an active search for employment where he failed to complete background checks for potential employers. Again, they're addressing me as an employee when their stance is that I'm an independent contractor. You can't have both. You know what I mean? You can't misclassify me as an independent contractor but come at me with employee defenses. You understand what I'm saying? But this is what they do. You know what I mean? Their fifth objection was Smith was not an employee of ERS, as Smith was not put on a schedule or directly supervised in his work, and Smith was not limited in his ability to perform similar work for other businesses. I'm going to address that as well. I'm going to address that. These are their objections. You know, I filed an intervening brief, you know, addressing that BS. You know what I mean? But I want to take y'all to Pidong Jia versus Unemployment Compensation Board of Review. And we want this is what I'm saying. I'm going to address this. This is a 2012 case law that was decided by the Commonwealth Court of Pennsylvania. And in this case, it is established that the board's only finding related to the status as an independent contractor is finding of fact number 8, that the claimant could work for other contractors as long as there was no conflict of interest. This is basically what they just said. They said that I was free to perform my work for other employers. However, you know, further on in this case, it says the contract specified that she was free to perform services for other parties while working for the employer. In that case, the board specifically found that the claimant had no supervisor and worked with other independent contractors and was paid by the client. However, the claimant testified that she was not and never was customarily engaged in an independently established trade or business. This court reversed the board, holding that despite the fact that claimant could work for others, the evidence did not show the claimant was customarily engaged in an independent business. This is my argument with Effluent Retrieval Services, that they never established that I had an independent business of my own. You know what I mean? They never established that. Here are some documents that they submitted to the federal court. This is one of their affirmative defenses. This is the first response to my civil complaint. It says plaintiff, me, was terminated for failure to work pursuant to Effluent Retrieval Services requirements, and that plaintiff failed to show up for work. But they didn't say I was an independent contractor. They said I was terminated as an employee. So, again, you know what I mean? What was Judge Papert looking at? I can't say I'm not sure. Again, you know, it's the injustice that pro se litigants face, you know what I mean, due to, you know, the how can I say it? Due to the unpopularity of pro se litigants. You know what I mean? They do not want pro se litigants winning in court. In fact, what they do after pro se cases is they close our cases. You know what I mean? Sometimes they allow pro se case, like my pro se case is on the books now in the federal court. You know, at the district level. Here's another submission by the defendants, EFFLUENT Retrieval Services. This is the employee sign-in worksheet. My name is on there, but ironically, it's the employee sign-in worksheet. Like, it doesn't say independent contractor sign-in worksheet. It says the employee sign-in worksheet. I don't know why that wasn't taken into consideration. Judge Patriot has his reasons. This is interrogatories, my interrogatories, which were answered by the defendants. It says here, plaintiff elected. This is the defendant's EFFLUENT Retrieval Services response. Plaintiff elected to begin working with ERS on September 30th, 2015. I said September 29th. He was paid $11 per hour. He was not entitled to and held no job title or formal position. Now, this is in the federal court. This is not the Unemployment Compensation Board of Review. This is in the federal court. This is a document. These are documents in the federal court. Excuse me. He was not entitled to and held no job title or formal position and was paid for work performed each day he elected to on his own accord work for EFFLUENT Retrieval Services. He was supervised by Jonathan Beagle, which is the owner, Manuel Rosario, which is an employee, or Ryan Labden, which is another employee. That's 3 people I was supervised, yet they say I wasn't supervised. And I'm gonna go into something else about this, about what he says about the supervision. Plaintiff work dates are presently being compiled and documentation will be provided. There is no record of plaintiff's productivity. There were no procedures for evaluating performances of day laborers at EFFLUENT Retrieval Service. Now I'm a day laborer. He's calling me a day laborer. It's crazy. This is the memorandum of law by the defendants. It says plaintiff Reinard Smith worked as a day laborer for EFFLUENT Retrieval Service. Now, mind you, a day laborer and an independent contractor are not the same thing. Day laborers are more closely connected with employees. On a few scattered days in 2015, he then severed the relationship between himself and ERS when he stopped sporadic appearances altogether. Now, that's a materially disputed fact, because I said I was terminated. They said I left. However, you know, that wasn't a material disputed fact for Judge Patriot. You know, District Judge Patriot didn't see that as a material disputed fact. Let's continue. On the few days that he did work, Smith was one among a group of individuals selected on a daily basis by EFFLUENT Retrieval Services to work for the day wiping cars down at auto auctions. Smith and others were picked up at one location and transported to second location to do the work. There was no obligation by Smith or other workers to return day to day. If they showed up and were selected, they worked, even if there was a long break in their attendance. Smith's relationship with EFFLUENT Retrieval Services was attenuated and inconsistent at best. But I'm a day laborer, not an independent contractor. He says in his supplemental answers to my interrogatories, plaintiff's work consisted of wiping down cars at auction lots, and plaintiff was not supervised or given training for this work. Now, and the first one where I read that he said I was supervised by 3 different individuals, that was his first response to my interrogatories. And his supplemental answer to my interrogatories. He said that I wasn't supervised. Like, this is what I mean. Like, Judge Patriot allowed them to consistently switch up their position. You know what I mean? Under the scheme of they have the right to present two alternative defenses. But again, a misclassification is not an intentional misclassification of an employee is not a defense. All right, so those are just some submissions. I want to get to some other things. You know, this is a case from the Third Circuit. Sherichetti versus PJ Endicott Company. This is a 2012 case. It's a Fair Labor Standards Act dealing with wrongful termination. And it says right here in the blue, I'm going to read it for you. It says the overarching question of the economics reality test is whether plaintiff was economically dependent upon the defendant or was in business for himself. Again, that was a materially disputed fact. As I said, I wasn't in business for myself. I didn't have a company. I wasn't incorporated. So what type of independent contracting business or work was I doing? Wiping down cars is not an independent business. It's not a customarily profession that one is engaged in. It doesn't have its own lane. Wiping down cars is part of washing cars, which washing cars is an independent business. But the act of wiping down cars is not an independent business. You know what I mean? So I'm still trying to figure out, like, what's going on, Judge Patriot. Like, we just not getting, the correct legal rulings, you know what I mean, on this stuff. And I don't want to sound cynical and things like that. I'm just saying that, here it is. You have a judge who's not new to this to wrongful termination litigation. You know what I mean? Very well respected judge, but he's overlooking a lot of main things in this matter, and I'm not understanding. I'm not feeling it. I'm not gonna say I don't understand it. I just know that this needs to be brought to the public because the courtroom is not being filled up. You can't see what's going on, so anything can happen because they don't have to be held accountable for what people don't see. Once it goes on the books, oh well, it's over with, whether people see it or not. But right now, while it's still in court, I want to bring it to the public's attention. Now, this is my reply brief in federal court to the Third Circuit Court of Appeals. My introduction says, the critical issue to decide in this appeal is whether I was in business for myself or was I dependent on the defendant's business for the opportunity to render my services. An independent contractor is one who has their own business or is in business for themselves. Their services have a market in which they can be provided. In the present matter, there were no marketable services identified which I can be charged with possessing or exercising. My duties were to wipe down cars. Defendants cannot make the claim that the mere act of wiping down cars has an independent market. The only market that is available is the services of washing cars, which entails wiping down cars, but the act of wiping down cars alone is not an independent business, trade, or profession, which defendants may be trying to imply. However, if I am not in business for myself or own my own business, then how could it be possible for me to be an independent contractor? As such is a needed factor in assessing whether one is an employee or an independent contractor. The district court granted summary judgment incorrectly for defendants as they failed to meet this burden of proof. Summary judgment should therefore be reversed. That's my introduction. My argument is the defendants misstate several key points of law and fact and failed to address the in business for himself part of the issue. Throughout defendant's brief, the defendants failed to address and misstate several key points of law and fact in an apparent attempt to confuse or complicate the issues raised by this appeal. As a preliminary matter, therefore, these misstatements require correction. First, the defendants failed to address whether I was in fact in business for myself or that I own my own business. This failure seemingly is to take all focus off a major factor in finding the established differences between who is an employee and who is an independent contractor. The defendant will have it such that there is another status which lies between independent contractor and employee, which is day laborers. The focus they are emphasizing is my duration at defendant's workplace. However, there is no between independent contractor and employee. If I was not in business for myself or own my own business, then I was an employee, no matter how short of a duration I remain at defendant's workplace. Also, if my duration is a factor to that extent, then where I had relayed I was terminated should as well been taken into consideration. I was not in business for myself, therefore evidence of termination would be highly material. But it wasn't taken into consideration. Defendants have not submitted even a scintilla of evidence showing I was in business for myself or that I own my own business. Such a showing is mandatory under the economic realities test. The courts have agreed that the ultimate question is whether one is in business for themselves or are dependent on an employer to render their services. I list 5 cases that point that out. 5 cases. Without evidence that I own my own business or was in business for myself, the only conclusion which can be reached is that I was dependent upon defendants and thereby an employee. Accordingly, and by law, the decision that I was not dependent upon defendants is not supported by the record, and this court should reverse the district court's decision. This top paragraph, I list 5 cases that say the overarching question of the economics reality test is whether plaintiff was economically dependent upon the defendant or was in business for himself. Excuse me. Now I want to get to the impermanence or indefiniteness that the defendants are constantly using, saying that, I had such a short duration with their company that implies that I was an independent contractor. However, what the law says is impermanence or indefiniteness points to independent contractor status only if due to operational characteristics intrinsic to the industry. I'm going to break that down. Defendants in their appellee brief, contrary to law, overshadow what is the economic dependent focal point with the permanency factor. And while my time with defendants was short, such short time must be measured against the operational characteristics intrinsic to the industry. And the industry in which defendants have a place, transitional workers are the norm. Lack of traditional employment structure is the norm, and permanence is the norm. So a short duration of working does not automatically transfer a day laborer into an independent contractor. Defendant's position on this point of the economics reality test misplaces the importance of what truly determines who is an employee and who is in business for themselves. The law is clear. A worker's lack of permanence or indefinite relationship with an employer is indicative of independent contractor status if it results from the worker's own independent business initiative. Right down here. And I cite the case that says that. I go on to say, I was not exercising independent marketable skills which could ensure me employment absent the employer's business. Although defendants make the claim that I was not an employee, they simultaneously have failed to specifically identify what do my independent contracting services allegedly consist of, as wiping down cars has no independent market. Defendants heavily rely on the control factor, yet attempting to distance themselves from the fact it was defendants who chose and permitted me to work. Defendants persist to misstate the law by trying to center all the factors on my work attendance. However, the factors are more like guiding tools, in which, in this instance, were incorrectly applied. Here's another part of my argument. The statements were not decisions in which a specific intent can be attached to. Also, my initial response was that my statements were not decisions. The reality of the matter is, when I first started working for defendants, I was unemployed and striving to get used to the way in which I had to leave for work. Due to these two circumstances, I had trouble making it to work, where even had I got to the pickup location late, there would have not been anyone there to take me to the work site. They only transport a certain number of workers to a site. My choice would have been to show up for work even when I'm late, as I did so on occasions. The result of my showing up late at the pickup location was a missed day of work due to the 18 to 20 workers who were already chosen. When I was questioned as to the reason I didn't show up for work on specific days, I relayed the subjective circumstances which befell me several times concerning my statement as to me being responsible for my absence at work. I first stated I don't think it was a matter of choice, given it was my intention to make it to work. However, once it was clear that I needed to be there to be amongst the workers needed, showing up late didn't make sense, for it wouldn't accomplish anything. The routine was to be there on time the next time. Appellees in their brief tried to make my clarification of their incorrect view of my testimony about my reasons for being absent at work equivalent to a sham affidavit. These are legal terms that y'all not readily familiar with, so I won't get heavy into that. But you can see, like, it's a lot going on concerning. I'm just looking through these, looking through all my materials, making sure I cover everything. Because I definitely want to cover everything. I don't want to leave nothing, you know, unclear, because it's a legal stake in this matter. I mean, it's a monetary stake in this matter, and you know, when you get served injustice, you basically are robbed of your monetary award. You know what I mean? Meaning you don't get to enjoy the fruits of your labor. And I've labored for this. I put the time in, research in, you know, I stayed steadfast. You know what I mean? And I deserve the benefits and the fruits of my labor, just like other people with their skills and their talents. You know what I mean? They get to enjoy the fruits of their labor. You know what I mean? They get to basically get paid for their craft. You know, unfortunately for me and the craft that I chose, it's a little more complicated, a little more difficult, a little more harder, because I have to rely on a judgment rendered by somebody who may not be fair, who may not want to see me, you know, get the monetary award. And that's the injustice right there. That's the stuff that, you know, I have to face, and all pro se litigants have to face. You know what I mean? I should be up right now. I should be, you know, counting big money. You know what I mean? Because I prepared myself well in the legal field. Like, it's not my first civil suit. I had many civil suits. I had a criminal matter, you know what I mean, that I should have won. But, you know, due to the circumstances and everything that was at stake, you know, they refused to allow me to win, because a win that big by a pro se litigant would have created not ripples in the water. They would have created tsunami. I mean, they would have created, you know, massive waves and tsunamis. I mean, I always mispronounce that word. You gotta excuse me. But they would have created tsunamis in the water, because to have single-handedly beat that matter, it would have just spoke so many volumes. But the thing is, I still deserve recognition for that, because I did it. You know, regardless of whether I was robbed for my glory in the judicial system, I did it. I literally single-handedly beat that matter. I beat that case. You know, and I'm gonna get into that case. I'm gonna bring out the facts just like I did. And this guy wasn't able to bring out all of it because I left the legal memorandum by the district judge, Gerald Patriot, home. So you know, but like I said, you know, he basically made a ruling on erroneous facts. You know, the fact that I made a retaliation claim based on being terminated by an employee of Effluent Retrieval Services. That wasn't the case. That's not what happened. You know what I mean? So, you know, it's just like the defendant said, you know, he can't be held liable for acts of his employee. So that was a way Judge Patriot allowed the defendant to escape, you know what I mean, my actual claim, which was I was terminated for filing a complaint by the owner of Effluent Retrieval Services. You know what I mean? But these are things that happen to those who don't really have a voice. I don't really have a voice. This is my only way of having a voice right now, by recording this and putting some of the facts before the public. This is my only way to have a voice. So this is what I have to do, because there are monetary awards at stake. I don't want to be robbed again. I should be able to have, you know, those rewards for what I labored. You know what I mean? Like, if he terminated me falsely or wrongfully, then he's liable for that. You know what I mean? And that's just the bottom line. That's what it is. I'm not trying to use this to make the matter sway unjustly my way. I'm using this to put the facts into clear view, and the errors and the things that are being done, so you can see that it's always an injustice. It's always a means of trying to stop a brother like myself, a black man, from making money. This is something I can be making money with, but if they keep undermining me, then I can't make money, because nobody will see that I have a winning streak. Nobody will see that I know what I'm doing. So, you know, these are the things that are going on and keep a lot of brothers from, you know, getting the fruits of their labor. You know what I mean? Like other people with their crafts who get the fruits of their labor. You know what I mean? We unfortunately have different means of acquiring our monetary awards or getting paid. You know what I mean? You know, I love what I do. I'm gonna continue to do it because I love it. You know what I mean? But it's just simply, you know, I probably got to do other things because my craft, a lot of people, or excuse me, the judicial system doesn't favor my type. You know what I mean? The alpha male, the pro se litigant, the black man, they don't favor my type. You know what I mean? And right now, in this time, it's a real serious war, like I said earlier, against the alpha male, against the pro se dominant litigant, against the dominant black man. You know what I mean? It's a war against us right now. You know what I mean? People may act like